Yeah, can you hear me? I can hear you loud and clear.
Yep, same on my end. Okay.
Looks like we're just missing Nathan Blake. Otherwise, we're good to go. So I think you can go ahead and get started.
Okay, all right. I'll kick off on our preamble here and let me get my video up. All right. Good afternoon. Welcome to the monthly meeting of the City of Des Moines Zoning Board of Adjustment. My name is Mel Pins. I'm the board chairman. And today's meeting, the process basically is the same as it would be if we were all meeting in person. But I just like to take a moment to welcome everybody visually to our hearing today. I will be switching off the camera. That saves on bandwidth and connection speeds. But I just like to give everybody kind of a welcome here in person. And I'll kind of read through how our process works for today. And we'll guide everybody through the process, so don't worry about that. But I'll go ahead and get started on kind of our preamble here. First of all, the Zoning Board of Adjustment has the power under Iowa law and the zoning ordinance of the City of Des Moines to hear and make decisions on requests for variances and exceptions from the zoning ordinance, to consider ordinances, conditional uses, and appeals from any decision of the staff in the administration of the zoning ordinance, and to make decisions in such matters. The members of this board are citizens of the City of Des Moines and have been appointed to the board by the City Council. The members of the board are volunteers and they receive no compensation for their public service. I'm going to take a minute here and introduce our board members. We have a 7-member board, and our members are Nathan Blake, Cindy Smith, Marlis Jones, Lynn Carlson, Dave Gare, Justin Gross, and again, my name is Mel Pins. I'll introduce our city staff who will also be assisting us today. The staff includes the board's legal counsel, Judy Parks Cruz, and then presenting and assisting in the background, Bert Drost, city planner, Eric Lundy, city planner, Jason Van Essen, city planner, Catherine Dawstart, city planner. The city's zoning enforcement officer is Sue Ann Donovan. Our meeting moderator today is Tyler Hall. Our planning administrator is Michael Ludwig, and also assisting with some of the setup and background, meeting moderator Glory Parks. While this is an open public meeting, we try to be as informal as possible, but this is a legal public hearing. It is being recorded for both audio and video. The board members have each received a copy of the agenda and the staff recommendations. The board is required to base its decision in each case only upon the criteria established by law for the type of relief sought by the applicant. The law applicable to each case is identified in the written staff report. If the facts, as determined by this board, demonstrates that the criteria established by law for granting the relief has been satisfied, then the board must grant the relief. Otherwise, the board must deny the relief. Each item will be announced in the order that it appears on the agenda. Items listed on the consent portion of the agenda are not planned to be individually discussed. They will be considered for approval in accordance with the recommendations in the staff report, unless there's a person present here who does not agree to the conditions recommended by the staff report, as in the appellant, or if there's an individual or a board member that objects to the conditions and granting the requested relief. If they request that the item be removed from the consent agenda, then it will be, so a full discussion of the matter can occur. After an item has been announced, staff will first give a brief overview of the appeal and present any written comments received prior to the hearing. Then the applicant or their representative will be allowed up to 10 minutes to present their appeal. We will then move to the public comment portion of the hearing, and anyone wanting to speak in support of first, opposition to secondly, or perhaps in neutrality, but maybe they have some comments for us to consider, In that order, we will take comments, and those speakers will be allowed up to 5 minutes each to present their comments. This will be their one and only opportunity to address the board. And again, I'll go over that as we go through each agenda item. So if you do have comments, we'll find a way to get you in here. This is just like we would do it if we were meeting in person. So after all have given public comment, the applicant or their representative will be allowed up, or I'm sorry, once all citizens have spoken, the board will ask any additional questions of staff, and the applicant will be given 3 more minutes for a rebuttal or other closing comments. And just as a reminder, if you do want to make comments to the board, if you're participating by Zoom, please click the raise hand icon on the participants panel if you're participating by Zoom at the time that we call for comments. That will allow you to be recognized by our Zoom monitor here. If you're participating by telephone, at the time that we call for comments, press *9 on your phone. And again, the meeting moderator will then know to call on you. We will then unmute your microphone and acknowledge that it is your turn. If you are then participating over the phone after you've hit *9 and we've recognized you, you'll also have to hit *6 because your phone call would have been muted. Again, we'll guide you through that. So we haven't had any problems with people being able to participate by phone or by Zoom. If you have any documents that you're using in your presentation, if those have not already been provided to staff, we need to have a suitable copy of all documents, pictures, photos, drawings, etc. You will need to email those to planning@dmgov.org. Again, you'll need to email those things that you want to use here as part of your record today to planning@dmgov.org. Okay, and just as a reminder, we ask that all speakers are requested to first give their name and address before addressing the board. Your address, if you're a resident and are concerned about something in, on, or around your property, you give your address of residence. If you're here in a professional capacity as an attorney, engineer, architect, sign company, etc., you can give the address of your place of business. So again, we'll need your name and address before your comment. Let's see. All speakers are requested to remain courteous and to focus their comments only upon those facts that demonstrate whether or not the criteria established by law has been satisfied. Speakers are asked to ensure that they are respectful of time considerations, and if necessary, the board chair will limit further comments by a speaker if they exceed their time limitation. So we try to be as generous as we can, but we got to keep things in boundaries here. And if need be, I do run the timer here. So after everybody has commented, the board will close any further public comment on the agenda item. The board will immediately deliberate the request, and we will make a decision here today. Please note that it takes at least 4 affirmative votes of the 7 members for any zoning appeal to gain approval. If your appeal is approved today, we would ask that you wait until next week if you would need to contact the city's Permit and Development Center for any necessary building permits. This will allow the decision of this board to be documented in the form of a decision and order. You will be provided a copy of that once it's signed and completed, and our Permit and Development Center will also receive a copy. Any appeal that is approved today by this board must be implemented, constructed, or otherwise utilized within 2 years of the date of the decision by this board, or such approvals shall expire. The decisions of this board can only be appealed in the district court. So if you believe you've been harmed by an error made by this board, your only remedy is to seek relief through the district court within 30 days of the filing of the board's decision and order. If you believe the zoning regulations applied by this board are wrong, you may petition the city council to change those regulations for future considerations. All material written or otherwise used today as part of any presentation is part of the permanent record, and you may contact staff after the hearing if you would need a copy. And finally, we ask that you keep your microphone on mute other than when addressing the board. This will limit distractions during the hearing that is in progress. We also ask that you refrain from using the chat or any question and answer functions here within Zoom as part of the meeting. Those are not planned to be monitored, but they could be considered as outside communication or what's called ex parte communication to the formal hearing process. So that's all I've got here. So I'm going to turn it over to Mr. Drost and see if we have any changes.
All right, thank you, Mel. This is Bert Drost, planner for the city of Des Moines. The only change to today's agenda is that item number 2, an appeal at 225 Watrous Avenue, has been removed from the agenda. So the public hearing will not occur today on this request.
Okay,
So
all right.
skip number 2. So we just have the one item on the consent agenda today for the board's consideration.
Okay, all right. So so again, item 2, we will not be considering that on the public hearing agenda. So as I noted, we have one item on consent, meaning staff has recommended approval of this item, and that would be to grant a conditional use approval at 3121 Forest Avenue through the Neighborhood Development Corporation as related to a conditional use approval for retail sales of alcoholic liquor, wine, or beer. So is there anyone in the audience that's participating by phone or by Zoom that would object if the board would consider granting this conditional use approval? So we'll just kind of look through here with our meeting moderators. If you want to object in Zoom, hit the raise hand little icon function down in your little toolbar that I think is at the bottom or to the side. If you're participating by phone, hit *9 if you'd like to be recognized. If anybody again wants to object to granting the conditional use request for 3121 Forest. Bert, Tyler, anyone? Do we see any requests?
No, I did not see any hands raised.
Okay, all right. So I will ask our board, you don't have to reply unless you have a concern. Is there anybody here that would object to granting the conditional use approval? And if I don't see any, would there be anyone from the board who would want to make a motion to grant the conditional use approval at 3121 Forest as a single item as it is present on our consent agenda?
Mr. Chair, this is Justin Gross. So moved.
Is there a second?
This is Marlis. I will second that.
Okay, so we've got a motion and a second. So it's kind of a dual vote here. We would be voting on approving the consent agenda, which basically is approving item 1, a conditional use approval for 3121 Forest Avenue. We'll take a roll call here with yes or no on granting the conditional use approval.
Nathan Blake,
Yes.
Lynn Carlson,
Yes.
Dave Gare,
Yes.
Justin Gross,
Yes.
Marlis Jones,
Yes.
Cindy Smith,
Yes.
and Mel Pins.
Yes.
Motion carries 7-0.
Okay, all right. So if you were here for item 1, that has been approved. As I mentioned, the decision and order will be signed probably early next week on that, and we will get a copy of that to the applicant and our Permit and Development Center. So we'll move on here then. That'll bring us to our first item on the full discussion agenda. Item 3, which is a zoning variance request. And the address for that is 400 Southeast 6th Street. And I will turn this over to our city staff and they'll give a brief introduction on the variance request.
Chair, members of the board, Jason Van Essen with the city planning staff. We're considering a variance to the sign regulations and chapter 134-5, which prohibits painted signs other than historic signs, murals, and signs in or on windows. This is an aerial identifying the subject property. It's on the northeast corner of Southeast 6th and East Martin Luther King. The building is on the western part of the site. Photograph of the property, looking back towards it, towards the north and east. The subject sign is the painted one on the side here. There's a sign on the front of the building, the rear, that permits have been issued for that comply with the zoning code. Just a couple more photographs. I'll go ahead and flip through the submittal information. You receive a copy of the staff report in your packet. Identify the relevant criteria for reviewing a variance, that hardship criteria. And, you know, we've had a lot of discussions over time with signs and variances and the variance test. And although this sign is aesthetically pleasing, the applicant hasn't demonstrated that they face an unnecessary hardship. We believe the land in question can yield a reasonable return from the permitted uses in the districts and the signage that is allowed. Therefore, staff is recommending denial of the request.
Okay.
Response map, some cards, had more cards. All in favor. Happy to answer any questions the board might have.
Sure. Board members, any questions for Jason?
Jason, this is Justin Gross. Are we talking about then just the cantina sign that's kind of a banner across the building? Is that the one in question? The other one was permitted, right?
Yes, that is correct. There's two signs have on the north and south ends of the building. There's permit issued for them. They comply with the zoning code, excuse me. So yes, today's discussion focused solely on the painted sign on the west side of the building.
Okay, thank you.
Other questions? Jason Melpins here. Just kind of a fundamental question. Businesses do have a right to a certain amount of signage based on square footage, number of signs, etc. But this appears to kind of hinge on the fact that the sign was not affixed to the building, but rather the characters or the lettering was painted directly on the building. So why do we have a city ordinance that does not allow for painted signs?
Well, the nature of how those signs, how you can regulate those within a zoning ordinance leads you to have limited ability to say, does this aesthetically fit or not? I think it's when you look at this photograph, I can pull it back up. I think in this case, the applicant has done a very tasteful job of painting this appropriately. It looks clean. It's looks professional. But the problem with allowing painted signs in general is that you open the door to things that are not as well put together and are a distraction or a detriment to the community. And so that's the reason why that sign type is prohibited, except for in those cases where it's a historic sign or something that's painted in a window.
Right. So if I kind of applied that to some things I've seen in the past that I think you guys have dealt with, probably through enforcement, not necessarily in front of us, but I had seen where people would just, quote, hand letter a sign or use a spray can and write liquor on a store. And again, not aesthetically pleasing, probably wasn't going to stand up to the weathering and didn't meet the intent of community character for quality and signage. Would that be kind of a general way to describe an instance of what you define there?
Yeah, absolutely. I think that's a great way to summarize it.
Okay. And when the applicant did present their kind of profile or elevation drawings of the facades of the building, did they show that they would have a sign on this west facade, at least outlined with a rectangle?
I'm not aware if this was presented to anything that would have been looked at when they came in for building permits.
Okay. I just saw in those drawings you had, were those drawings that were submitted ahead of time, or were they just submitted as the fact of today?
They were submitted with their Board of Adjustment application.
Got it. Okay. All right. And not to belabor this, but one final one. The city's recommendation is denial of the variance. If we denied the variance, they would still be allowed to, in essence, keep the aqua colored stripe or keep the red stripe on the west side. They would just have to, in essence, kind of fill in the lettering there so it doesn't say Rita's Cantina. Is that correct?
Yes.
Okay. All right. So general color schemes, building trim, stuff like that can still be allowed to be painted.
Correct.
Okay. All right. Excellent. Okay. Any other questions for Jason? Going once, going twice. Okay. All right. Well, Mr. Van Essen, thank you for your good presentation. So now the way the hearing works, the applicant or a representative of the applicant gets to speak first. They have up to 10 minutes to present the reasoning for their appeal. And we need them to start by giving their name and address. And staff may know who wants to be recognized here, but just for the record, if they're participating by Zoom, hit the raise hand, or by phone, *9. And we'll get you recognized here.
We have Andy Massis, so he should be able to unmute himself now.
All right.
Okay, can you hear me?
Yes, Andy, go ahead.
Okay, my name is Andy Massett. Address is 2811 Northeast 96th Avenue, Ankeny, Iowa, 50021.
Okay.
And basically, I am the one who painted the quote sign. When we do a concept, I usually try to take them to the nth degree as far as authenticity. And what we were trying to do here was basically duplicate what I would call, say, a roadside cantina you might find along Route 66 in the Southwest, New Mexico, Arizona, etc. And it's an oversight by me, but I honestly did that as basically an artistic enhancement to the concept. You would normally see that's what was done. I do have several examples that I would have shown at a live meeting, but that's obviously not possible. So, you know, honestly, at the time, I viewed it as a work of art to go along with the concept, and looking back, maybe I should have, rather than using the business name, it should have been something else, like a message, or maybe what we serve there, or what we are, or something like that. So that's really the background of it, and that's all. That's the only difference I have, I guess. So
Sure. No, that's a honest presentation. I understand what you're saying about Route 66. Board members, do you have any questions for Andy?
This is Lynn Carlson. I don't know if it's a question for Andy or staff, but he was talking about putting names of what they serve there. But from my understanding, they can't do that, but he could put pictures there.
Yeah, that's, I would encourage him, if he moves forward, to look at doing something else, to work with Sue Ann Donovan, zoning enforcement officer, to find that I don't want to call it middle ground, but the ground where it is art. Because if it said, tacos or something that they sell, it's still considered, it'd be signage from my understanding. So, but I don't know if Sue wants to chime in on that, but certainly we'd need further discussion.
Thank you.
Anyone else have any comments or questions for Andy? Okay. Andy, again, this is Mel Pins here. Yeah, I like the idea of themes on a building and having a style. I totally get that from a design standpoint. But yeah, we also have to be very careful about what is considered signage. Signage is regulated. perhaps we'll be inclined to approve the variance, but if we are not inclined to do that, as I mentioned earlier, at least for the short term, if the variance was not approved, would you be able to kind of fill in or fill over where it says Rita's Cantina, and still kind of retain that stripe and color theme there? Would you be able to modify that fairly easily?
Yes, I would. I still have some of the paint, and
Okay.
it's just a matter of turning the white letters into the teal color. So
Right. Okay. So the whole building, the west facade doesn't need to be stripped off of all paint or anything like that.
no, not
Okay. All right. Okay. We'll just do going once, twice, then again. Any other questions for Andy from the board members? All right. Seeing none, we'll check back with you in a minute here, Andy. So
Okay.
now we'll take other public comments on this item. Is there anybody here by Zoom or phone that wishes to speak in support of the applicant's variance request? If you'd like to speak in support of this, in granting the variance for them to keep the quote sign, the painted sign, please hit the raise hand icon in Zoom or *9 on your phone if you'd like to speak in support. If you're participating by phone, hit the *9 key if you'd like to be recognized to speak in support. Going once, going twice.
I do not see any.
Okay. Is there anybody here that wishes to speak in opposition to granting the variance request? So in other words, if you don't want the request granted, we'll give you a turn to speak. Anybody that wishes to speak in opposition to the variance, hit raise hand or *9 on your phone.
I do not see any either.
Okay, and same sign if you just like to talk about signage for 5 minutes. Anyone else?
Nobody.
All right. Seeing no requests for public comment on this item. Let's see, do we have any final questions for the board? Or I'm sorry, do we have any final questions for staff? Or does staff have anything that they'd like to add? Staff doesn't have to.
Chair, members of the board,
Yes,
this is Sue Ann Donovan, Zoning Enforcement Officer.
go ahead.
I'd like to point out that this request does not meet the variance test, and I think that the request should be denied.
Okay. All righty. Clear enough. Andy, you just wrapped up your comments, but you do have the opportunity to present a rebuttal of up to 3 minutes. If there's anything you would like to add to, or as Sue Ann had mentioned, the staff's position on this, anything else you want to say in closing? If not, no big deal.
I understand if the code doesn't restrict it, that everybody that opens up a business can walk around and just with
All right.
paint a paintbrush and
Yep.
paint a sign. So
Okay. All right. Well, then we'll go ahead and close the public portion and go to board deliberation. So board members, any thoughts on this one?
I think it's important to maintain the law as it is, and the person who painted the sign's obvious, agreeing to go along with it and sees the point to it. So I would be in favor of recommending or going forward with staff recommendation of not allowing this. There's no reason that it has to be there. There's ample signage elsewhere, and I think the colors will stay there, and will still, people recognize that as being Rita's Cantina, or the colors that you see with the Southwest. This is Des Moines, New Mexico.
Okay. All right. Thank you, Lynn. Anyone else? Okay. All right. There's no other comments on this one, just to kind of move things along here. I would kind of agree with Lynn on that. It should be noted there is other signage on other facades of the building that does meet the city's sign permit requirements. So generally speaking, there is visibility for people to know what the business is and that they are arriving. So I'm going to go ahead and make a motion here. Oh, sorry. Is there a comment by someone? I'm going to go ahead and make a motion here then to deny the variance request at 400 Southeast 6th. So
I
will
will
there be a
second
second?
that.
All right, so got a second by Lynn. All right, so we'll take roll call for denial of the variance. All those in favor say yes, those opposed say no.
Dave Gare,
Yes.
Justin Gross,
Yes.
Marlis Jones,
Yes.
Cindy Smith,
Yes.
Nathan Blake,
Yes.
Lynn Carlson,
Yes.
and Mel Pins.
Yes.
That motion carries 7-0.
All right, so Andy, don't take this one personally or professionally. This is just kind of a nuance in how the zoning ordinance does work. It is very important for the public character to regulate signage. But murals, artwork, building color schemes, generally speaking, would not be regulated. But I would encourage you to check with staff on any other modifications you'd like to do here. And certainly down the line if you're getting into other projects. But this is a good property owner and a very good business. And I know you do very good work yourself. So I wish you well in the future on this. Thank you for coming in today. Okay, that'll bring us to item number 4, which is a zoning variance request at 432 East Locust. And we'll turn it over to staff for an introduction here.
Mr. Chair, members of the board, this is Eric Lundy, city planner. This is a variance request to allow a projecting sign that would be within 10 feet of an existing projecting sign that's already on the block on another property. The agenda item describes the area of the sign and how it will be mounted 9 feet above the sidewalk. The subject property is a building located just west of the intersection of East Locust Street and East 5th Street in the gold outline here. For the most part, the building takes up the balance of the property except for a few feet at the back on the north side. This is a photo of the building as it currently sits, and you can see the sign on the upper left-hand corner of the kitchen collage on the building to the west. That is actually the sign that is creating the separation consideration. This is the property to the east on the corner of East 5th Street and East Locust, owned by the same owner as the building that we're discussing. And its entrance is oriented to the corner, so I should point that out. This is a little closer in, so you can see where that sign is mounted with that property to the west. And then I should also point out that to the west of there is another sign that projects as well. So the flexibility for this sign is really not there because it meets separation as it stands. So there really isn't any negotiating with this owner to shift their sign to make it a little easier to meet the requirement for the subject property, because this sign is already also in place on the next property to the west. So it sort of has started to set a pattern. You know, I don't know if the expectation is that, you know, a property owner should work with multiple property owners to sort of reconfigure things. In this case, you know, these are established signs.
Mm-hmm.
And then I'm kind of zoomed out so you can again see where we're talking about. And then they made their application. This shows what they're proposing. And as you can see, the building is essentially 20 feet wide. So it's actually impossible for them to place a projecting sign on this building and meet the requirement of 30 feet of separation. They happen to be proposing it in the center of that 20 feet, bringing that separation down to 10 feet, which throws them into the variance situation. This is the schematic they're showing for their theme for their sign program. This is a mock-up of how that sign would project. You can see the existing sign in that mock-up on the building to the west, and you can see there would be a partial obstruction just in the walking down the sidewalk if that sign is allowed in that location that's being requested.
Mm-hmm.
This is
Eric, could you tell us how there's a blockage with walking? I don't follow that.
So this is you can see like an individual walking on the street. This is a perspective.
Yep.
As you're walking down the street, and so you can see that the mock-up location of where this sign would partially obstruct this other sign.
It
Not
blocks the other
completely.
sign.
Yeah. I think they were trying to also demonstrate that maybe it doesn't completely obstruct it, which that is also the case.
Okay, gotcha.
This is a structural schematic of how that would be mounted onto the facade. There's a header that you see right here. I'm going to go back onto this photo, and it might be a little easier if I zoom in a little bit. You can see this right here. Structural element, I believe they would be anchoring it in this location based on that schematic.
Okay. All right.
This is the staff report, which has the applicable regulations, information about, the property and the criteria by which the board has to consider this, and then the staff recommendation. Staff does not believe that they are demonstrating meeting the test for variance. We believe they wouldn't even require a projecting sign. They could continue with the use of the premise without a projecting type sign. So the relief that's needed isn't absolutely necessary to continue a reasonable use of the property. Staff believes there's some practical aspects of this, of course. The first one being you can't even mount a projecting sign and meet the requirement. You'd still need some relief. A type 2 exception can be considered for half of that 30-foot distance. So the board could consider a type 2 under the criteria for type 2 relief, type 2 exception relief at a 15-foot of separation, which would have it essentially 5 feet from the east wall or east property line of the building. And that would be allowed to be considered. Staff believes that's still, from a character perspective, still problematic. I think as much as this could be mounted to the east of the building and make that separation as great as possible, I think that would better meet the character of the established kind of cadence of those projecting signs that we see on the block face. Staff would thinks that we could find that that situation would meet the test for a type 2 exception, with the practical difficulty being that, it could be mounted. It might need to still be mounted on that header and not on that soft brick in terms of where it would make sense. But if you look at that, the east edge of that header, you're nearly at the property line. You're maybe a foot or a foot and a half west of the property line. This would be the property line. The reality is that this is also probably 6 to 8 inches west of the property line. So something in this area would be, even if it was mounted on the east edge of this header and still able to take structural advantage of that, that's maximizing the ability to separate that within the 20-foot wide building there. So staff does believe it could meet that test, and staff would recommend approval of a type 2 exception. While we recommend denial of the variance to go less than 15 feet at 10 feet, we are recommending approval of a type 2 exception for 15 feet less than the minimum separation of 30 feet for projecting sign. And we want to make sure that they have proper issuance of the sign permit. And we also want to ensure that any projecting sign would be installed as far east on the building as possible, given the practical ability to structurally mount the sign on the building. So we didn't want to get so tight with our recommendation as to create an issue with the actual physical mounting of the sign in a certain location that doesn't work. So that's where we're recommending at this point. We've gotten a few cards in favor and in opposition from surrounding property owners. I'll scroll through those. We had one in opposition, and I'll show the map so you'll be able to see where that is. That would have been a condominium owner to the southeast. We had 3 condominium owners to the west, and then property owner immediately to the west was in favor of the request.
And Eric, can you show that comment card that was in opposition again? Does it say ruins appearance of building that is close to property that I own, that I
Yeah,
am?
I think that's, yeah, yep.
So the sign would ruin the appearance of the building, is their contention.
Yeah, I think they're concerned about the aesthetic aspect of it.
Okay, all right. They more than likely did not have an opportunity to actually see what the sign was, though. That doesn't go out with the notice, does it?
No, they could contact us and we would provide them any information.
Got it.
In the application that they would want to look at, so, or have any discussion. They just sent their
Yep.
And I can't speak to anybody contacting. I only had one call personally on this matter from one of the notified people, and they did respond in favor.
Okay. All right.
Yeah, in fact, that was, so if you look at this first card, they're in favor of it, but they said, please take the sign as far east as possible. So even being in favor, they are wanting that sign to be placed as far east as possible.
They also said 15 feet would be great. Gotcha.
There you go. There you go.
All right.
So that's the, if you don't have any questions.
We'll find out. Let's see. Do we have questions for staff? Board members? Who'd like to go first?
This is Lynn Carlson. I got a question. You says on the type 2 exceptions, 15 feet less, but you want as far east as possible. So we should say, because the 15 feet less, doesn't that say he has to put it at 15 feet? If we can say anywhere, change it to as far east on the building as possible. Do we need to change that wording any?
So I worded it in such a fashion as not having made the assumption of where that could be mounted structurally. It's possible that 15 feet, it's possible that the header at the east edge of that header isn't strong enough, and I didn't want to make that assumption.
Okay.
So I wanted to keep
anywhere between 15 feet and the building.
The relief can be as close as 15 feet, the way that's worded, still being in the type 2 exception level.
Yep.
But giving them some flexibility on mounting it in a fashion that still works physically.
Thank you.
Right. Other questions for Eric?
Eric, this is Nathan Blake. Could you, I think you kind of talked about this, but can you go over the rationale for the original, and I understand that you're not the policymaker, but could you at least explain the rationale behind this requirement of separation requirement?
I think going to the ordinance itself, it's really meant to actually protect existing signs for one, so that they're visible, you know, as they're projecting signs are generally intended to be visible to motorists and pedestrians that are walking along the street front. And so by making them too close together, they obstruct each other and they don't, you know, they're not effective, you know, from that standpoint. So we wanted to create with the ordinance a reasonable amount. And 30 feet was probably based on the typical bay width. In this case, you know, we're talking about 20-foot bays on an old historic area. So that created a situation where, you know, 30 feet wasn't even possible for every building then to have a sign. So that's what puts it in front of the board. But it's based on getting a reasonable separation on these projecting signs and not having them clutter and block and obstruct each other.
Mm-hmm. Eric, kind of a statement and question. I might also assume that having some minimum separation distances is also a density issue, so that we don't have a million Burma shave projecting pop-up signs as we walk or drive down our corridors.
Yeah, it's to reduce the clutter as well. Yes.
Yeah. Okay. Other questions for Eric? Eric, I've just got one closing one. On one hand, you say you want to make this simple for them. Staff is proposing an exception level, and you don't want to tell them where to put the sign, but then you're trying to tell them it's got to be as far east as possible.
We want it to, it's preferable that it's as far east as possible, but we didn't have enough information to say, you know, ideally it would be at, you know, in where the brick column is, but that I can tell you that could be a challenge using soft brick to support the sign. And so then potentially why, you know, we might be inclined to grant the variance. I don't know, but if we're not, we want to grant an exception. Couldn't we just say, hey, it's got to be a minimum of 15 feet from the other sign? Then they decide how to best mount it. They decide how they'd like to place it. Because if I was them, I'd want to have it centered over my little picture window there, as long as I was 15 feet away, rather than have us tell them how far east it needs to be. Yeah, I think that being as far east as possible does the best to meet the intent of the code.
Okay.
So,
all right. So, I'll give you that.
So from that, you know, that's why staff, certainly the board has it within its ability to grant a type 2 anywhere between 15 and 20 feet, basically.
Okay. All right. All right. Any other questions for Eric? Okay. Seeing none, we'll go ahead and have the applicant present. Applicant or their representative, you get up to 10 minutes. We need you to start with your name and address. And staff may know who this is, but hit the raise hand sign or *9 on your phone and we'll get you recognized.
Yeah, this is John Parker with Parker Signs and Graphics. 1286. Hi, hello. Mr. Chairman and board members, thank you for your time. I'm at 12869 Geneva Street, Indianola, 50125. I guess kind of our reasoning of why we wanted to do a projection sign is, you know, the intent of that neighborhood is a pedestrian feel and movement of people, and also very slow traffic for any of the traffic that is through there. With that, you know, a sign flat on the building, it makes it harder to see from farther down the block as people are walking. Completely understand the situation with the zoning. I serve on the city council in Indianola, and we've been going through our zoning ordinance as well and trying to clean up and updates and things. So I completely understand. You know, we also understand the variance situation to allow for situations like this where the property is so narrow that there's no way that we could meet the recommended distance of 30 feet. We of course would appreciate being able to place it at the middle of the property here at the 10 feet. While there is, some interference with signs back and forth as you're walking and you're down low on the sidewalk, those obstructions are pretty minimal as you're walking along. But we also understand that if nothing else, we just want the projection sign, and if we have to put it on the east end of the property, then we can do that as well. But like I said, we would prefer to have it centered over where the door entrance is.
Yep. Okay. All right. Anything else you want to add, or would you be prepared for a few questions?
Got questions would be fine.
All right. Board members, any questions for Mr. Parker? Okay. Well, pretty straightforward here, it looks like. Okay. All right. Well, John, we'll check back with you here in a few minutes. We'll go ahead and see if we've got any audience questions. So do we have anybody here participating by Zoom or phone that wishes to speak in support of the applicant's request for their variance to allow for their sign? Hit the raise hand function in Zoom or *9 on your phone to be recognized.
I do not see any.
Okay. All right. So same sign for those that wish to speak in opposition. Hit the raise hand function or *9 on your phone and we'll recognize you. Anybody to speak in opposition to the variance request?
I don't see any either.
Okay. All right. And anybody with any just general comments about signs? Same sign. All right. I don't think we have any there either. Any comments from the zoning enforcement officer?
Chair, members of the board, I would just like to say again that the sign doesn't meet the variance test. The request doesn't meet the variance test.
Okay.
And I think the board should not grant the variance, but could very well grant the exception.
Okay. All right. Any questions for city staff? From the board, going once, going twice on that. Okay, I see none. So Mr. Parker, we do have the appellant's rebuttal. You don't necessarily have to do this if you don't want, but since we really didn't have anybody speaking in opposition, aside from staff reasserting their position, is there anything you want to add in closing, John?
Nope, I just, other than, thank you for your time and looking
Sure.
into this,
Yep.
Okay. with that area being a nice pedestrian area, we just want to make sure that they're able to see the bar, so.
Gotcha. Okay, thank you, sir. All right, we'll go ahead and close the public portion and go to board deliberation. So colleagues, anybody have any initial thoughts on this one?
This is Nathan. I think everyone on the board, although probably not everybody in the audience, is well aware of my adherence to pretty strict interpretation of the variance standard. And unfortunately, I don't think that they've made their case. I do think that the underlying law is kind of silly. I think 30 feet is, this is a great example of why that's way too much. But it's not in our role to make policy. It's our role to apply the law. I guess I would support what staff has recommended and hope that the appellant can, kind of figure out a way to make that look good. And I would support the 15 foot just to give them as much leeway on that right side as possible or the east side to figure out how it looks best and where structurally it makes the most sense. So I wouldn't want to charge them with doing like as far to the east as possible or anything like that. But
I'm with you.
I think they've made their case for the type 2 exception.
Right. So basically you'd be in favor of the exception meeting condition 1, but from your perspective, there'd be no need to have that condition 2.
Correct.
Gotcha. Okay. All right. Other thoughts from the board?
I agree with Nathan. This is Lynn
Okay.
Carlson. And so I move that we accept the type 2 exception with only the number 1 condition, remove the number 2.
All right. Would there be
I'll
a
second.
second for that?
This
That
is
was
Nathan.
Nathan? Yep.
And just to clarify, that means you want to recommend denial of the variance and approval of a type 2 exception.
I think that is correct for the intent, and
Yeah.
we can cover both with one motion, correct?
Correct.
Yeah.
Yes, you can.
Yes, that's
That was
correct.
the intent. I was having problem unmuting.
Yeah. So basically, we have a motion for a denial of the variance, but approval of an exception level as listed in staff report with condition number 1, but scratch condition 2.
Correct.
And that was a motion by Lynn and a second by Nathan. Any other discussion by the board before we vote? Okay, all those, we'll take a roll call here. All those in favor of denying the variance but granting the exception as presented, yes for that, or no if you don't want.
Justin Gross,
Yes.
Marlis Jones,
Yes.
Cindy Smith,
Yes.
Nathan Blake,
Yes.
Lynn Carlson,
Yes.
Dave Gare,
Yes.
and Mel Pins.
Yes.
The motion carries 7-0.
Okay, all right. Thank you, Mr. Parker, for representing your client today, and we look forward to stopping in.
Thank you for your time.
You bet. Have a good evening. Okay, then that'll bring us to item number 5, which is a zoning variance request at 400 Southwest 7th Street.
Mr. Chair, members of the board, Catherine Drehaus, planner for the city of Des Moines. This case does have a number of similarities to our earlier case presented by Jason. A little context, the site is located in the just south of the viaducts, literally just at the top of this map is where the 7th Street viaduct begins as it heads north. The applicant is looking to retain a couple of signs on the building that were painted on. Give you a little bit more closer view, and I can zoom in if needed. That was on the south side of the building, and then this is on the north side of the building. For many of the same reasons that Jason stated for the previous case, signs that are painted are not allowed unless they are historic murals or signs that prohibits, and then signs that are in windows. So similar to what Chairman Pence has already explained is that painted signs just, we have this provision so that signs aren't just spray painted with a can of spray paint and somebody out having just decided to go ahead and spray that on the side of a building. And so for that reason and several others, as you already know, we are recommending denial of the request for the retention of these signs. Our consent map, we did not receive any cards back to the notification mailing, and I'd be more than happy to answer questions, but I don't want to belabor the case as it's so similar to one we've already had.
Do we have questions for Catherine?
Mr. Chair,
Board?
this is Cindy. Can you show us where their signs are that are allowable?
Signs
Is
that
there
the-
other signage on the building?
To be honest, I think that's a question best suited for the appellant.
Sure.
Trying to recall from my site visit if I saw other signage on the building.
Okay.
Nothing comes to mind, and I'm not seeing it as I scroll back through the photos. Again, I would suggest that the appellant may have further information.
Okay. Other questions for Catherine?
Catherine,
this
this is Lynn Carlson. Is this an old building or is this a new construction?
This is completely new construction.
Thank you.
Catherine, this is Justin Gross. I don't see anything listed as pulling permits for any signs. Is that right?
I might ask Bert to help facilitate that question.
And Justin has a very good question. Yeah, based on any site plans or elevation or profile drawings, did the applicant show that they would have a name on the facade of the building in any form?
This is Bert Drost, planner for the city of Des Moines. When the applicant submits site plans, the signage isn't reviewed at that time. They might show a sign on the site plan, but the staff's general comment is always that the signs are considered separately at the time that a sign permit is issued.
All right. And to the best of your knowledge, was a sign permit issued for anything at the property, just based on what you might have handy?
I don't believe so.
Okay. All right. Any other questions for staff? Okay. All right. Seeing none, let's go ahead and hear from the applicant on this. And do we have an applicant recognized yet? They just got to hit raise hand or *9 on their phone. Looks like we've got a raise hand.
Yes, it's Tim Portson. He should be able to unmute himself now. There we go.
Hello, this is Tim Portson with Hubble Realty, 6900 West Town Parkway, West Des Moines, Iowa.
Hi, Tim.
50266.
Go ahead.
Perfect. Just to answer a couple quick questions, that is the only sign that we have right now. And I think while there are similarities to the Rita Cantina sign variance request, there are some unique differences. One, while during site plan approval, they do not approve the signs. I just want to clear up that it was on our site plan as a painted sign. I think what's unique about this is when we submitted for site plan approval, we were under a different zoning ordinance that I believe would have allowed for it. That was kind of always our intent. Had we pulled a permit at that point, we may have been issued it and been able to do a painted sign, and it would have been great. However, we were 12 months away from having the building complete and being able to paint the sign on there. And then zoning changed and we kind of got into this situation. One of the questions was, is this a new construction or an old building? And I love that was asked, because it was totally our intent to design this building as if it were a historic building. The Hubble family owns a lot of the buildings in this south of MLK corridor, formerly known as River Point. We've done historic renovations of rocket transfer lofts, River Point lofts, stuff like that. So it was definitely our intent to pay homage, make this building look like it was a historic building. So I think for us, unlike Rita's Cantina, who was kind of trying to do a Southwestern theme, and to us, this really is an artistic expression. It is a mural. It is a way for us to, while the sign is not old, the paint has not been there for 50 plus years, we do believe that it is historic signage. It's meant to emulate the historic signage that's in the neighbors. And it really adds to the character of the area. But I'm happy to answer any questions you have.
Okay, do we have questions for Tim? Well, Tim, I'll give you one here quick. This is Mel Pins. So you kind of referenced, yeah, it was your intent to have this on there. So if it was considered a sign from square one, did you apply for a sign permit?
So no, I could make the argument. I'm not going to. I can make the argument that we don't believe it's a sign. We believe it's a mural. I'm not going to go there. Ultimately, to be honest with you, to be 100% honest with you, what happened is typically we have a signage contractor do our signage. and
Yep.
they pull permits for us and they do it. And because this was more of an artistic painting, we had a painter do it. And the painters do not know to pull permits, and our contractor did not catch that either. So no, ultimately we did not pull a permit.
Okay, all right. Okay, other questions for Tim? Okay, all right. Well, Tim, thank you for your presentation. We'll go ahead and see if we have some other comments here for or against your request. Okay, anybody here to speak in support of the applicant's variance request? Hit the raise hand sign or *9 on your phone. And do we have one hand up there, Bert?
I know that's still Tim Portson's.
There it goes. Okay, now it's down. All right, anybody here to speak in support of the request? Sign on your phone to be recognized. All right, seeing none. How about anybody here to speak in opposition to the applicant's request? Same sign to be request to be heard.
I don't believe so.
Seeing none. All right, anybody here to speak in neutral? Just to talk about signs or murals or painting. Okay. Also seeing none. Any comments from the zoning enforcement officer?
Chair, members of the board, Sue Ann Donovan, zoning enforcement officer for the city of Des Moines. I think they have pointed out that it's not a mural, although they kind of danced around that, but this is definitely not a mural. It's not art. It is absolutely a sign and would have required a permit that didn't get pulled. If they would have pulled the permit, we could have addressed this at that point and told them they couldn't do it. They don't have any non-conforming rights for approval for a painted sign because they put it on a site plan. It is absolutely and always true that after the building is constructed and you want to do a sign, you're required to come in and pull a separate permit for evaluation and approval. This does not meet the variance test and therefore should not be approved.
Okay. All right. Any questions for city staff from the board members? Okay. All right. Appellants rebuttal. So Tim, if there's anything you'd like to add in closing here, you've got up to 3 minutes. You can use it or don't have to, up to you.
I don't have a rebuttal. I think I've stated my case as best as I could. I do want to point out that while unfortunate how this played out, the painted sign is there. We did use a paint that is specific to brick adhesion. If our variance is not granted, I totally understand and appreciate that. And I want to do as best as I can to write that. I think our intent would be to do to pull a permit and to do a actual sign that would be of similar size, similar logo, but on like an aluminum sign on standoffs. And then we would apply that directly over the painted sign. We will try our best to get that paint off that brick. But I want to be clear that I can only do what's in my ability.
Yeah. Yep. Yeah. Yeah. Sometimes there's some practicality in carrying out the intent of the ordinance. Unfortunately, the board can only rule on general issues. How it's then carried out to the satisfaction of the planning administrator, that's not entirely up to us. So. Okay. All right. Well, at this stage, then we'll go to board deliberation. Thoughts from the members?
Hey, Mr. Chair, this is Cindy Smith. We've heard we've had lots of sign issues brought before this board. And I've often wondered when when the applicants sit down with the city staff and review the site plan, do they not have a bulleted item that says, let's talk about signage? Because, this isn't the first time this has been brought forth, that, it was part of the site plan, but wasn't discussed. And then when Sue Ann, I appreciate what Sue Ann was saying, but I think it's up to the city to make sure that the applicants and the folks who are submitting these site plans, it's really clear to them what they need to do for signage. I personally like the way this sign looks on this building. I think putting a aluminum sign up, I'm not sure that's gonna look better. I think it looks good. It looks clean. It really fits the building. It makes it just gives it a nice feel. I really don't have a problem with it. And I know there's a variance issue, but this isn't the first time we've been kind of had sign issues brought before us that make us all stop and not even know how to react to it.
Yeah. Yeah.
Chair, members of the board, may I address that?
We closed public comment and went to board deliberation. So I don't know that I want to do that unless we
That's
allow
fine.
Tim a chance to give a further rebuttal.
That's fine. Thank you, Chair.
Yeah. Board members, any other thoughts?
This is Lynn Carlson. Of course, I have a thought.
Very good.
I do like the look of it because, the historic buildings, I enjoy going downtown and seeing the old faded paint that comes through and makes it look historic. And I like the fact that they were doing that with that. And that's why I was hoping that this was a historic building that they had rehabbed and we could include it. It's a hard thing to say, is where do we follow the strict line of the law and where do we go with something that makes sense?
Yep. That's also a conundrum. Other thoughts? I'd also maybe want to throw out something. Yes, it's always easy to kind of pick on the regulator that, well, the regulations aren't clear enough, or if they're your regulations, you should make sure that everybody's following them up front. And but the regulations apply to the most inexperienced developer, a one-timer developer, and they apply to the most experienced developers. So kind of a little what's good for the goose is good for the gander. Here we have one of the best and most experienced developers on a multi-million-dollar project. And the developer didn't go, maybe I need a sign permit. Maybe we should double check. It appears that this was delegated downward, which I understand that. That's why you hire people to do work for you. But if that was not done or done improperly, well, maybe that's why they have errors in emissions insurance. But the buck ultimately stops with the property owner or the developer. So the developer should have double checked on this one. That's some of my concern. But yeah, it generally looks nice. It fits. There's not a lot of signage there, but this is kind of a tough one. But there's an ordinance that's in place that says that this is not allowed. So any other thoughts or any motions from anyone?
This is Nathan. I'll move to deny the variance request.
This is
All right.
Marlis. I will second that.
All right, so we've got a motion for denial of the variance request by Nathan, seconded by Marlis. So we'll take a roll call vote on denying the variance request. All those in favor will say yes, opposed, no.
No doubt about it. What a fantastic shot from Kale. So
Marlis Jones,
Yes.
Cindy Smith,
No.
Nathan Blake,
Yes.
Lynn Carlson,
No.
Dave Gare. Sorry, what was that?
Yes.
Justin Gross
Yes.
and Mel Pins.
Yes.
And motion carries 5-2.
Okay, all right. Okay, that's a very nice project and a very nice building, but we do have some regulations on the books. So we appreciate you coming in today, Tim, and hopefully you can work through this with the city for something that remedies the situation. as simply as possible.
Yep, thank you for your time.
You bet. Have a good afternoon.
You too. Bye-bye.
Okay, so item 6, our last item on the agenda, is a conditional use approval request in the vicinity of 400 Walnut Street.
Right, Mr. Chair, members of the board, Bert Drost, planner for the city. This last item is a conditional use permit that would allow a use of area within the Kirkwood building for a bar and assembly or entertainment use with sales of alcoholic liquor, wine, and beer throughout. The subject property is located at the southwest corner of Walnut Street and 4th Street in the downtown core, just to the south of the Capitol Square building and a little bit to the north of Court Avenue. This next slide here shows the footprint of the building. And so the bar and entertainment venue that's being considered today is within this western portion. It's in the tenant space formerly occupied as the Vivian's Diner. Here's the floor plan that they've submitted. It shows the lounge area on the main level, and there's a mezzanine level as well. And then they would have these patio areas along Walnut Street to the north of the building. Shows the floor plan of the mezzanine level. This is looking at it from Walnut Street. Again, it was recently occupied by the Vivian's restaurant. Another angle, you can see the new 5th Street parking garage going up immediately to the west. This is looking at it from the corner of 4th. There's Wasabi Tao restaurant in the eastern half of the main level. As far as our staff recommendation goes, we do believe that this is an appropriate location for a bar and entertainment venue. It meets all the criteria necessary for granting such. It's in the DX1 district, which means it does not need to meet separation distance requirements. I would mention that staff has 2 small edits to the staff report that was sent out on Friday. It's on your screen now. The first is condition number 3. It says any sale of alcoholic liquor, wine, and or beer for off-premise consumption shall be prohibited. And we're just qualifying that to say unless otherwise authorized and allowed by the state under the state liquor license during the COVID-19 business relief directive. I also want to mention that this is the only condition that the applicant is in disagreement with. So he'll be focusing on this during his discussion, or I'm sorry, during his presentation. He would just like a little more flexibility in the ability to sell beverages and take out containers. He's not wanting to sell full bottles. It's just the mixed drinks and takeout containers, which has been pretty popular with other bars during the pandemic. And then the other change to the staff recommendation was condition number 6. That was an oversight that was meant to be replaced by the condition number 5, which just says any speakers or amplified sound within the patio area shall be in accordance with the sound or Class E sound permit only, which limits the amplified sound to levels that are considered background auditory in nature. So the rest of the conditions are the standard conditions, nothing this board hasn't seen before. So I won't go through those, but here's the consent map. It was a mixed bag, half in support, half in favor, or I'm sorry, half in opposition. I'll just leave these up on the screen as I go. But
are those people who live in the Kirkwood though, or are those people who live at?
It's in the, most of them are from the plaza at 300 Walnut Street.
Yeah, okay.
We did get one from the Kirkwood building. But
the Kirkwood building itself has probably now dozens of residences in it. Is that correct?
Yeah, I believe the upper 10 stories are all condos. So
okay. And only one card from the people who live in the same building where this is to occur.
Yeah.
Okay.
So I'll flip through these quickly. So now, if anybody had any questions for me, now might be a good time to ask those.
Yeah, questions for Bert?
Bert, this is Nathan. What was the staff's rationale for excluding what seems to be an issue or what you flagged as issue, given the fact that we are experiencing some really difficult times and those mixed drinks have been popular in many houses around the city, including mine?
Right. Well, that's actually a standard condition that we've been putting on bars these days. Just says no sale of alcoholic liquor for off-premise consumption. It was when the applicant reached out to me earlier this week that he said he didn't agree with that. Then I took a second thought. I'm like, yeah, they make a good point that I have heard of a lot of bars that are, using that strategy to hang on during these hard times. And so that was why we recommended that we expand that condition to say, unless in accordance with the state requirements during the pandemic. But if the board is obligated to strike that condition or amend it, I don't think staff would fight you too hard on it.
Are
Other
there
questions
just
for Bert?
a quick follow-up on that?
Yep.
Are there have you guys developed any language that is more specific to, say, like bottles or anything, like restrictions on bottles being sold rather than like mixed drinks or something else?
I don't think staff has drafted any conditions. I think when I got an email from the applicant just before the meeting, and it sounded like that might be something he proposes, said the board doesn't allow him to sell bottles, but would allow him to sell mixed drinks. So I might have you ask that of the applicant.
Okay.
So then the last few slides here are just showing you the neighborhood outreach that they did. They did a great job reaching out to their neighborhood, and they had a virtual Zoom meeting, and they had a lot of good input from the neighbors.
Cool. Okay.
So that's all I had. Are there any other
Okay.
questions, or I'll turn it over to the applicant?
Bert, just a quick one, and I don't want to belabor this, but if existing old conditional use permits around the city didn't allow for the off-premise, consumption or takeout, but yet you've allowed that during the pandemic through other policy, why can't we just write this as a normal conditional use permit and then you slap on your own kind of lifting of restrictions, carte blanche?
Yeah, I guess that would be a possibility as well. I might let Sue answer that if she would like.
Chair, members of the board, I'm sorry, I missed that question.
So my question was, a normal conditional use permit for a tavern or bar has a ban on takeout liquor, correct?
Correct.
So why can't we just continue to have that as the standard conditional use permit for here, but then with whatever good nature the city council's had on policy on allowing takeout within parameters, then you kind of apply that on your own? Why do we want to change around a permit at this time for one specific location when then we might have to come back in later and fix it?
Well, Chair, members of the board, Sue Ann Donovan, I think I would see it as the city of Des Moines is following state guidelines on what they're allowing under a liquor license. That did not come from us.
Okay.
When COVID started, they said to restaurants, you can also sell mixed drinks to go as part of a meal delivery or a meal purchase.
Yep.
We're not interfering with that.
Okay.
All we were trying to do in this decision in order is clarify that If
Okay.
you want to strike it, we're gonna treat it just like we do any other conditional use permit. When the COVID is restrictions are lifted, they're gonna go back to exactly what the state
Anyway.
authorizes
Okay.
that liquor license to do.
All right. All right. Well, this may not be that big of an issue then. We'll see what the applicant has to say. All right. Thanks for that clarification. That kind of helps me. All right. Any other questions for staff? Okay. All right. So now it is the applicant's turn. So if they haven't been recognized yet.
Yes, Brad Goldman should be able to speak now.
Good afternoon. Can you guys hear me okay?
Yes, Brad.
Fantastic. Well, my name is Brad Goldman, and my address is 3315 Waco Court, Des Moines, Iowa, 50321. I'd like to thank the board for hearing our request today. I'm currently in the process of purchasing this commercial real estate. We're still under our due diligence time period, and approval of this conditional use permit is part of that due diligence. Essentially, we're working on creating a social gathering space and an event center where cocktails, music, art, and technology come together to create a unique cultural experience in Des Moines. Without going into too much detail about our operations, at the end of the day, I'm happy to answer any questions that you guys might have about any aspects of our planned operations. And very specifically, including what we're doing in regards to sound control and isolation, because those are a big deal for us. But today, I think we really kind of are focused on one specific issue to comment on staff's recommendations. We're very supportive of all of them and are in agreement. But in review, we wanted to dive in and talk about number 3 a little bit and discuss to clarify, I think, all the other conditions we very much expected and understood that they would be in place. This one, we wanted to talk about a little bit more given recent developments with changes in Iowa's law. And so our position on that is, and we had to kind of get ourselves up to speed on those recent developments. But so our position is that it's not our interest or intent to sell bottles of liquor or cases of beer for off-premises consumption. We believe that there should be a condition in place that prohibits the sale of alcohol in the same manner as how liquor stores operate. Therefore, we're not necessarily requesting that this condition be stricken completely. Instead of creating this condition in terms of the COVID-19 Business Relief Directive, we would instead like to request that the condition be based on House File 2540. In summary, the COVID-19 Business Disruption Relief Program was not limited to, but it did include Governor Reynolds allocating federal CARES Act funds to assist bars, taverns, and other establishments impacted by the August 27th COVID-19 disaster proclamation that closed bars in 6 counties. Eligible businesses were to receive a one-time $10,000 grant to assist with short-term cash flow. So this was a one-time thing and isn't particularly related to the business's ability to sell mixed drinks or cocktails to go. However, on June 29th, House File 2540 was signed into law. This legalized the sale of mixed drinks or cocktails to go by Class C liquor licensees. The legislation also authorized the state of Iowa Alcoholic Beverages Division to adopt administrative rules to implement the provisions of law related to mixed drinks or cocktails sold to go. So therefore, I'm suggesting that, this condition remain in place, but suggesting that the language may read something as follows. Any sale of alcoholic liquor, wine, or beer for off-premise consumption shall be prohibited unless the business holds a Class C liquor license and operates in accordance with House File 2540 and all applicable administrative rules, specifically IAC, Iowa Administrative Code Section 185 4.10, which addresses the filling, sealing, and sale of mixed drinks or cocktails to go. So that was a lot of words. I'm happy to discuss any of that from a practical standpoint or the details of any of that.
Mm-hmm. All right, questions for the applicant, or anybody want to have him expand on these questions? Well, sir, I have a question for you on this. I'll just lead off then. Your appeal, what you requested when you filed, was a conditional use approval to operate a bar.
Correct.
Yeah, so until the staff put this condition forward, this was not a premise or basis or something that you asked for permission for in your original application. You just asked to run a bar, correct?
I think that this for me is a clarification. It's my general understanding that by this new law being put in place, a bar is now allowed to sell cocktails to go. And so we wanted to take this opportunity to just discuss it and clarify. We understand if the conditional use permit, part of that process is to say, even though that law exists in Iowa, we want to put the condition on the bar to not be able to sell to-go cocktails. That's something that we're going to have to adhere to. But again, just really a clarification today. For us, this is something that seems to have become allowable since this summer. So we just wanted to talk about the condition that would prohibit something that just became law.
Okay. All right.
Is that law, is that in perpetuity, or is that just for addressing during COVID? Because I only read the first page of what you posted on there because the limitations on what we have in screenshots. Mm-hmm. So is there any time limit on that law? Is that like forever?
Yes, my understanding is this new law is in perpetuity. That's my understanding of it.
Dan, do you have a comment on that, or anybody else? Maybe Judy?
Well, that's what I'm reading, and from what I can see, I don't know. The language here hasn't shown me anything that would put a time limitation on this. And to be honest with you, I haven't read its provisions outside of this setting either to know whether there is some sort of date on which this would no longer become effective. Generally speaking, there isn't a sunset clause put into it, then they do go on until at some point that law changes.
Yeah.
I can add that the only reason that I knew about this to bring it up for discussion was that it was a headline, a news headline topic, that Iowa was the first state in the country to make this change permanently.
Mm-hmm. Can somebody skip down to the end of House File 2540? I'd like to see the date that it was signed. Okay, June 29th, 2020. And then that will be codified, so it would become like, Iowa Code 455G, 657A or something. So it's a House file now, but once it's in law, it will say what code sections, like code section 321.
Yeah, it'll probably be 123, I think is the alcoholic beverage.
Yeah, yep. So be that as it may. All right, so we're finishing questions for the applicant. Do we have any other questions for the applicant from the board? All right. I don't see any at the moment, so we will come back to you, sir, in just a few minutes here on this. So do we have anybody that wishes to speak in support of the applicant's request? And if you're here to speak in support, hit raise hand on Zoom or *9 on your phone. Anybody speak in support of the applicant's request? All right, going once, going twice. Is there anybody here that wishes to speak in opposition to the applicant's request? Same sign, hit the raise hand icon on Zoom or *9 on your phone to be recognized if you're in opposition to granting a conditional use permit for a bar at this address.
There's nobody else on the line, so I don't think there'll be anybody.
Okay. So there's probably nobody in neutrality either floating around in the universe. Okay. Okay, then do we have any comments from the zoning enforcement officer?
Chair, members of the board, this is Sue Ann Donovan. I got kicked off for a while, so I didn't hear all of the conversation on the state law question. But I would say that if you want to, you could change number 3 to say any sale of alcoholic liquor, wine, and beer for off-premise consumption shall comply with the laws of the state of Iowa. And then we can follow whatever the legislature does in regards to that.
Okay.
Good idea,
And-
Suann. That's what I was going to suggest too.
Just a question that I would have on that, Suann, while you are here. So state law was changed a few years ago to say, hey, you know what? We'll give you a state like liquor license and you can sell liquor in your convenience store, your grocery store, wherever you want. However, that same law allowed cities to have some say in certain terms. And that's why folks still have to come in front of us and why specifically the city of Des Moines requires separation distances to sell liquor to go. So what I'm getting at is not that specifics, but this House File 2540 seems to be kind of the new kid in class here. So are there any provisions in there where a city could say that it wants to have further restrictions? Or is this one, no, it's passed statewide and you local city ordinances can't have any impact on this? I would be concerned that if we just steamroll this in, without further study by the city, there may be opportunities where the city may or may not want to have further restrictions on that. Any comments from the city on that?
Well, I will, this is Sue Ann Donovan. I will say this. My understanding when this was passed without reading it was that it was in connection with COVID relief. I have not read it to the point where I understand exactly what it does beyond that.
Yeah.
So I can't answer that question today without looking at it further.
Yep.
Now you could further refine number 3 to say in compliance with the House file number. And then if that gets overturned at some point, then that provision goes away.
But if
without
it
getting into the
doesn't,
weeds.
if it doesn't get overturned, so he's the first one we've allowed to do this, then do we allow everybody else in the city to do this by default?
Well, if their liquor license allows them to do it, I don't think we can, well, I can't say that because I don't know what it says.
That's exactly right. And that is my concern because remember, a state law was passed that said, yeah, any pharmacy, grocery store, get and go can sell alcohol. But there were some provisions in there that allowed for some reasonable zoning for that.
Correct.
I'm a little bit concerned with a few aspects of this. So to keep this moving.
But Mel, wouldn't we then just say then it needs to adhere to state law and city code? And to the extent that there's a policy that's put in place by the city council with those types of restrictions, then this business would have to adhere to it rather than having it as one of the conditions for the conditional use permit, restrict them beyond what is otherwise allowed by state and local ordinance.
Well, I get where you're coming from, Nathan. I'm not trying to be obstinate here, but remember, a state law was passed that said just about any store can sell liquor. But that same state law hidden in there was a thing that did allow for some reasonable restrictions. And that's why we have all these cases about they got to be so far from a church and so far from a park.
Well, that's what I'm saying. And then, but the city council enacts those restrictions, which I think is totally reasonable, rather than like a one-off, before our board, kind of one-off restrictions on individuals who come to us, I guess is my...
I got you. So Suann, another question I would have, we could very well deal with this right now. We could decide to put this off for a month so everybody can talk. But I would think that the applicant, probably his main thing he'd like to do is open his tavern. So if we were inclined to grant a conditional use permit here today to run a bar or a tavern, could we not come back to specifics of this item later on for an amendment to the conditional use permit to maybe go beyond what the staff rec is?
I believe that you could pass it with the recommendations that staff has suggested, which would say that after COVID restrictions are lifted, that they can't sell for off-premise consumption. And then if they want to amend it later, they could come in and amend it.
Yeah.
You could continue it for 30 days, let staff read the state law and the file and see if we wish to address it somehow differently.
Okay. All right. So to keep things moving on that note, do we have any further questions for staff from the board?
I have a question legally. From my old government classes way back when, the state government, the cities can have more restrictive licensure than the state, but they can't have more liberal than the state. So we could be still more restrictive than what the state says, correct?
Not necessarily, Lynn. This is Judy Parks Cruz. There are some areas in which the state preempts cities from doing anything different than what the state has done. This may not be one of those because there is some room for cities to regulate location and spacing and that kind of thing. But I guess it depends on what the actual restriction is that we're looking at.
Okay, like I said, government was a long time ago.
Certainly, no question. Yeah, no worries.
Okay, any other questions for staff? All right, hearing none, then Mr. Goldman, you've got an opportunity for rebuttal or any closing statements you'd like to make. You get the last say here for up to 3 minutes if you'd like it.
Can you hear me?
Yes, sir.
Yes.
Excellent. I would say that you are absolutely correct. This is a due diligence time period and not necessarily opening, but rather making the final decision to purchase the property. We did want to get this conditional use permit in place to have a general awareness that we can operate, right? So, I would like to see that happen today. I would like to see this approved. I do believe that we should be able to do sale of cocktails for offsite consumption under these new laws and regulations. I guess I would suggest if it's appropriate to do so, that the board somehow approves this conditional use permit today. But I guess I very much am interested in coming back for the next meeting. I do think it's appropriate for everybody to have a reasonable amount of time to review these laws and administrative orders and such. But I'm a big believer that systems work well when there's not, contradiction or confusion in between different things. So I would like to be part of the process of seeing if this is a good fit and a new thing for the conditional use permit process, and would be happy to come back to the next meeting to kind of get a final ruling or potentially an amendment on this specific issue.
Okay. All right, Brad, very well stated. Okay. All right. Well, then we'll go ahead and close our public portion now and go to board deliberation. What do you think, colleagues?
So we're looking at approving it as written and then adding the state thing next month. Is that correct?
Well, that's just something the applicant mentioned. Depending on how heavy of a lift you want to do here, we have a request for a conditional use permit to operate a tavern in front of us. The city staff has provided their staff rec for approval, which generally speaking is similar to almost every other one. If we did approve it as staff's presented, there is nothing that would prevent him from coming back and asking for amendments to that for a variety of things. Okay. But perhaps to kind of hammer out this new state law in more detail later.
Because there was a bar there before. I think I'm fine with as staff has written it, but this new provisions, I think we need to study it a little bit more to know exactly what we're doing, but those are my thoughts.
Okay, any others?
This is Nathan. As I kind of previewed in my comments earlier, I'd be in favor of changing number 3. I mean, I'm definitely in favor of granting the conditional use permit. As far as condition number 3, I think I don't think there's any reason to hold this particular institution out for special restriction beyond what the city and the state have designed for, whether off-premise consumption is allowable or not. I don't think we've heard any arguments down that way. And so I'd be comfortable with number 3 reading something like, I don't know that we have to put anything, but we could put, off-premise consumption should adhere to, state law and local ordinance. And then they'd be put on the same footing as every other entity, rather than being, and I understand that to this point, it's often been included in conditional use permits, it sounds like, but because of, changing legal environments, it might not be the case in the future. And that way it gives the opportunity for the city council to wrestle with the issue however they want to for the whole city, whether they want separation restrictions or to ban it if they're able to under state law or whatever it is. But then we don't have to go through the process of having this particular applicant come back and deal with them kind of piece by piece in the future. I don't know that there's any argument that this particular bar is in a special position that should be restricted beyond whatever the city and the state think the restrictions should be.
Yeah,
Any
Cindy,
other thoughts?
I agree with Nathan. I think we need to just, and I don't know, was that a motion, Nathan, or just part of the discussion?
Yeah, it was just part of the discussion at this point.
Okay.
Mm-hmm. Any other comments? Okay, all right, well, anybody got any motions?
I guess, so I will move. I'll move staff recommendation, the updated staff recommendation without number 6, it looks like. Is that correct, staff?
Yes, that's correct.
Okay. And then change number 3 and to Judy, maybe you can pretty up the language a little bit, but something along the lines of any sale of liquor, wine, or beer for off-premise consumption shall be in accordance with state law and any local ordinances.
Yeah, that sounds quite reasonable. We can tweak it just a tiny bit when we write it, but that sounds good, Nathan.
And I'll second that, Mr. Chair. This is Cindy.
Okay, so we've got a motion by Nathan and a second by Cindy to grant the conditional use permit with some kind of minor clarification or language change in item 3 as was presented. So if that's clear enough for the record, we'd be voting yes to approve the conditional use permit or no against it.
Cindy Smith,
Yes.
Nathan Blake, Nathan Blake,
Sorry, I got off on my mute and unmute. So yes.
Lynn Carlson,
Yes.
Dave Gare,
Yes.
Justin Gross,
Yes.
Marlis Jones,
Yes.
and Mel Pins.
Yes.
That motion carries 7-0.
Okay. All right. Well, that concludes that item. So Brad, we will get this in a form of decision and order for you. So then you'll have all those conditions. And then if that helps you make your further decision here, hopefully things will work out for you.
Thank you very much. Appreciate it.
All right, you have a good evening.
Thank you.
Okay, so just a few items of business, decision-making wise, we have to approve minutes of the last meeting. Anybody who was here last month had any concerns with the minutes or any changes? Propose those now, or if there are no changes, is there a motion to approve the minutes as presented?
This is Marlis. I move to approve the minutes as presented.
I'll second. All right, second by Dave. All right, we'll take roll call.
Nathan Blake,
Yes.
Lynn Carlson,
Yes.
Dave Gare,
Yes.
Justin Gross,
Yes.
Marlis Jones,
Yes.
Cindy Smith,
Yes.
and Mel Pins.
Yes.
Motion carries 7-0.
Thank you, sir. All right, and Bert, do we have any just items of note, dates, issues, items?
Sure. Yeah, I have just 3 more housekeeping items. The first is that our December and January meetings are going to be held virtually. Again, I know last time we spoke, the order was set to expire at the end of November, but it has been extended now through at least December and January. So expect those to be held over Zoom. I'll keep you posted if or when it gets extended past January. And then also just wanted to point out again that the December meeting will be December 16th, which is the 3rd Wednesday of the month rather than the typical 4th Wednesday of the month. And then lastly, I just wanted to remind you that we're still planning to do the training session either before or after the January 27th regular board meeting, just depending on the length of the regular agenda, if we want to do it before or after. So I'll keep you posted on that as well. And if you have any topics you want to be covered on or covered during that training session, just send them my way.
Anybody got any questions or comments for Bert on those items? Okay.
No.
Okay. All right. Well, I think this concludes our board's business for the day. So I thank my colleagues and fellow board members for their time and dutiful attention, and staff, thank you again for all your support in carrying out this hearing. So I wish everybody a good evening.
Thank you, everybody.
Thank you.
Have a happy Thanksgiving and stay well, you guys.
Absolutely.
You guys as well. Take care.
Bye now.